Mr. Sheldon, I hope I haven't put you out by asking you to start a little earlier than you anticipated.
Not at all, sir. Good afternoon. So we're grateful for the opportunity to make this brief oral opening statement on behalf of the Secretary of State for the Home Department in her capacity as core participant, which of course is distinct from her role as the sponsor to this inquiry. As you're aware, we've also provided the inquiry with a set of written submissions, which we hope will be of assistance to you. You will have seen from our written submissions of the 21st of June of this year that the then Home Secretary decided not to make substantive submissions to the inquiry at the outset of Phase 1 of Tranche 2, on the grounds that to do so would be inappropriate in the period immediately prior to the general election of the 4th of July. And so this opening statement and the written submissions that accompany it are intended to address both Phase 1 and Phase 2 of Tranche 2. It is important to record at the outset that undercover policing is a crucial tool in tackling serious crime and keeping the public safe. However, the Home Secretary is appalled by the historical allegations under consideration by your inquiry and considers it vital that we now swiftly get to the truth about what happened and ensure lessons are learned for the future. At the outset of the inquiry's evidential hearings in November 2020, the then Home Secretary provided a detailed opening statement that addressed the genesis of the inquiry, the role of the Home Secretary in the Home Office, the constitutional and regulatory framework relating to the Home Office and policing generally, and undercover policing specifically, since 1968, and the relationship between the Home Office and the SDS. We've not sought to repeat those matters, which we are confident the inquiry will have well in mind. The inquiry announced on the 20th of September of this year that the Tranche 2 Phase 2 hearings would be postponed from the 30th of September to today, the 14th of October, to allow all those involved, including the inquiry legal team, additional time for preparation. The Home Office welcomed that decision and notes the importance of ensuring that the inquiry's proceedings are conducted fairly and that the core participants are able to provide the inquiry with fully informed representations. We recognise the constraints under which the inquiry and core participants are working, but notwithstanding these constraints, the Home Office has sought to assist the inquiry with an overview of the legislative and regulatory framework during the Tranche 2 period in relation to undercover policing, along with some preliminary observations on the evidence disclosed to date. However, sir, for reasons which you will be well aware of, it has not been possible to address the full substance of the Tranche 2 Phase 2 evidence, and the Home Office respectfully reserves its position as to whether the inquiry should afford core participants a further opportunity in due course to make representations on the Tranche 2 evidence at some point prior to the conclusion of the Tranche 5 hearings in 2026. Sir, I don't propose to take up time this afternoon by going through the legislative and regulatory framework we've set out in writing, but it is important and we would invite you to keep it in mind. In particular, it is important to note the overarching point that, as you recently observed in your note of the 16th of August this year concerning Module 3, quotes, the arrangements for overseeing undercover policing deployments are now very different from those which obtained in the past. That is certainly true. Prior to the enactment of the Regulation of Investigatory Powers Act 2000, RIPA, in October 2000, the use of undercover operatives was not governed by statute, but was instead underpinned by non-statutory guidance and codes of practice, and subject to rules established by case law and other statements of principle. The introduction of the Human Rights Act 1998, RIPA itself, and the Investigatory Powers Act of 2016 have all fundamentally reformed the legal context in which covert policing takes place. The present position is that all undercover deployments must be authorised at a senior level as both necessary and proportionate to the issue being investigated. Since January 2014, all police deployments of undercover officers must be authorised by an Assistant Chief Constable and notified to the Investigatory Powers Commissioner, formerly the Office of Surveillance Commissioners. In addition, Chief Constables must authorise deployments which last longer than 12 months and seek approval for such deployments from a Judicial Commissioner from the Investigatory Powers Commissioner's Office, as you know well. The level of authority for urgent authorisations, which expire after 72 hours unless renewed, has been raised from Inspector to Superintendent or equivalent. More recently, the Covert Human Intelligence Sources Criminal Conduct Act of 2021 has introduced amendments to RIPA, providing an explicit statutory regime for the authorisation of criminal conduct by covert human intelligence sources, such as undercover police officers. Such authorisations must be for specified purposes and only where necessary, proportionate, and subject to robust safeguards. The Covert Human Intelligence Sources Revised Code of Practice came into force in December 2022. It replaces the previous code, dated August 2018, and reflects the new statutory regime for the authorisation of criminal conduct by covert human intelligence sources within RIPA. So we've set out in writing the very different legislative and regulatory framework that applied within the Tranche 2 period. And the short point we wish to emphasise for present purposes is that the picture is dramatically different today to the one you will be considering during this phase of your hearings. So if I may, I propose to use just the last few minutes remaining to me to make some brief observations about the Tranche 2 evidence that we've seen thus far. As with Tranche 1, the Home Office has been following the evidence of the inquiry during the Tranche 2 evidential hearings with great care. The Department continues to note in particular any issues arising regarding the Home Office's role. The evidence has demonstrated that the Home Office, during much of the Tranche 2 period, continued to provide annual authorisation of the SDS to the Metropolitan Police. It is also apparent that in annual correspondence between the Metropolitan Police and the Home Office up to 1989, letters from the Metropolitan Police requesting approval of the expenditure provided a high-level description of the work of the SDS, with some brief examples of successes, and also provided assurances, again at a high level, as to welfare and supervisory arrangements of SDS officers that were in place. Beyond this process of high-level update and authorisation, the evidence seen to date suggests that the level of knowledge on the part of the Home Office with regards to the operational activity of the SDS was limited, in particular in light of the nature of the relationship between the Home Secretary and the police. The Home Office did not seek to direct the work of the SDS, nor did it monitor the manner in which that work was undertaken. There is evidence, however, to suggest that there was an agreement between operational partners not to inform the Home Office of concerns pertaining to the actions of some undercover officers, due to anxiety that the department would too closely examine the work of Special Branch and the nature of SDS sources. Right to say, though, that there is also evidence that on occasion, such as in 1986 and 1990, the Home Office did express direct interest in the undercover activity of the Metropolitan Police Service in relation to anti-fascist action and to the activities of extremist animal rights groups following an escalation of their violent activities. However, in each case, we have not seen evidence of any attempt on the part of the Home Office to engage in the operational management of the officers involved in the undercover activity in question. So as you know, Phase 1 of Tranche 2 heard evidence from former undercover officers and relevant civilian witnesses during the period 1983 to 1992. During the course of that evidence, there were, from time to time, questions relating to, or broad references to, quotes, government and or government concerns. So, as you will be well aware, government is made up of numerous departments, with the Home Office being only one. And it follows that the term Home Office cannot and should not be used as a euphemism or shorthand for government or for the security service or vice versa. And we are confident that you and your counsel will be vigilant to ensure in this phase of the hearings that when witnesses make assertions about what government did or did not know or do or approve, it is made clear what branch of government is being referred to for these purposes. We understand that the Tranche 2 Phase 2 hearings will hear evidence in relation to remaining officers focusing on animal rights deployments, managers and relevant civilian witnesses during that period. At the time of providing this opening statement, the Home Office is not aware of any evidence to suggest that the department or any Home Office ministers or officials were aware of the deeply disturbing behaviour and conduct of some undercover police officers in their deployments within the Tranche 2 period. Namely, sexual misconduct, the use of aspects of deceased children's identities to build cover legends, or conduct leading to miscarriages or potential miscarriages of justice. On the 3rd of November 2020, at the outset of hearings for this inquiry, the then Home Secretary's opening statement noted that the 2015 report by Stephen Taylor found that during the Tranche 2 period, a small number of Home Office officials were aware of some of the specific groups that were targeted by the SDS, the type of intelligence being gathered, and detailed operational activity during the years in particular 1983 to 1986. He found no evidence, however, that anybody in the department was aware of the SDS practice of using the identities of deceased children to form their legends, or of the risk that SDS officers may form sexual relationships with their targets. He also found no evidence that the Home Office had any direct knowledge of criminal activity and court appearances by SDS operatives that could lead to actual or potential miscarriages of justice. The Home Office remains unaware of any evidence to date that would call those findings into question. As for the determination of whether groups or individuals should be regarded as subversive, the only witness to suggest that the Home Office had any involvement in determining whether a group or individual was subversive during the Tranche 2 Phase 1 hearings was, as you will recall, HN 78. In his statement dated the 21st of April 2022, he stated words to the effect that the Home Office or Home Secretary deemed the Socialist Workers' Party a subversive organisation and/or must have considered the SWP appropriate to infiltrate. When questioned by counsel to the inquiry on the 31st of July 2024 about the basis for this view, HN 78 did not identify any evidence to support his assertion, and nor is the Home Office aware of any corroborating evidence from other sources. We trust that any similar assertions that may be made in this phase of the hearings will also be tested just as rigorously for the purposes of determining whether there is any evidence to back them up. So let me just conclude by saying that the Home Secretary supports this inquiry's aims and is committed to her department continuing to cooperate fully with its investigations. She notes your public commitment to publishing a final report in 2026 and awaits your findings and recommendations with great interest. Thank you very much, sir.
Thank you very much indeed, Mr. Sheldon. Thank you. Next is Ms. Quincy Whitaker. Is she yet ready to make her submission? Ms. Whitaker, good afternoon. I owe you an apology for misdescribing you as Mr. Whitaker. I do apologise. It was unforgivable. Despite that, I hope I may seek forgiveness.
Counsel, thank you, sir. This opening statement is made on behalf of Mr. John Burke-Monerville. He appeared because undercover police officers from the SDS spied on a campaign he and his family had established to obtain accountability for the mistreatment of his son, Trevor, in the custody of the Metropolitan Police. Trevor was diagnosed with brain damage following his arrest by Stoke Newington police officers on New Year's Day 1987, when he was 19 years old. Despite the passage of over 35 years, Trevor's family still do not know what happened to him that day. What they do know is that he disappeared from outside a nightclub at 1:40 a.m. on New Year's Day, was found semi-conscious and badly injured inside a covered car by its owner at 10:40 p.m, and was then, despite the state he was in, arrested by the police for criminal damage to the car and taken into custody. On the 2nd of January 1987, the police concealed Trevor's presence in Stoke Newington police station from John Burke-Monerville when he came looking for him, and over the next 3 days repeatedly prioritised prosecuting him and imprisoning him over investigating who had attacked him and ensuring he received proper medical care in the hospitals to which he was admitted for short periods. After Trevor was eventually admitted to hospital for emergency surgery to remove a blood clot from his brain, a medical report found evidence that he had been beaten multiple times, and the charges were dropped against him on the 8th of January 1987. The Trevor-Monerville campaign was set up shortly afterwards to discover what had happened to Trevor and to campaign for a public inquiry. It bore little fruit. Instead, Trevor and his family were constantly harassed by the police. Even Mr. Burke-Monerville, then 79-year-old father and 73-year-old mother, were subject to harassment. Trevor, who remained unwell as a result of the brain damage he had suffered, was arrested and charged numerous times with criminal offences during 1987 and 1988. All charges were either discontinued or he was acquitted. In March 1994, Trevor was stabbed 10 times on his way home from a friend's house. Despite there being several witnesses to the killing, no one has ever been brought to justice in connection with his murder. John's discovery in 2014 that the police had used surveillance on the Trevor-Monerville campaign during the time when he was trying to find out who was responsible for his son's mistreatment, rather than assist him in his attempts to seek answers and redress, has intensified the pain and trauma he and his family have suffered in a lifetime blighted by tragedy, stonewalling, and the consequences of endemic racism. This inquiry represents John's last chance to find some light in the darkness, to rescue hope from where it has shattered. John's family has suffered other unspeakable tragedies. His son Joseph was shot and killed in February 2013 on Hindley Road in Clapton. 3 individuals were due to stand trial in respect of Joseph's murder, but the prosecution was dropped. An investigation conducted following the family's complaints about the police's handling of the criminal investigation concluded that there were a number of failings. In June 2019, a third of John's sons, David, was fatally stabbed outside his home in North London, having been attacked by men burgling his home. The perpetrators were found guilty in December 2020. John believes that the Trevor-Monerville campaign was deliberately targeted by undercover police for seeking answers and justice in respect of police violence, racism, and corruption. He also believes that racism was responsible for the Stoke Newington police officers' treatment of his son and the harassment of Trevor and the rest of the Burke-Monerville family by Stoke Newington police in the years following Trevor's arrest. The failure to explain what happened to Trevor and the lies about whether he was in custody in Stoke Newington police station, and the failure to bring the killings of 2 of his sons to justice. His sincere hope is that the inquiry will achieve 3 goals for him and for the community as a whole. Firstly, to fully and properly investigate why he and the Trevor-Monerville campaign were targeted for surveillance by the police, instead of being assisted in their quest for information and accountability for Trevor's mistreatment in police custody. Secondly, to stimulate others to come forward to provide information about Trevor's contact with police on New Year's Day 1987 and the killings of his sons, Trevor and Joseph. He appeals to any witnesses to contact his solicitors, Bernard Pierce. and thirdly, to expose racism within the police as the rotten thread that maps these tragedies and police failings together. It is his firm belief that racism was at the heart of the police brutality and corruption that the black community experienced, and which many of the people who found themselves participating in this inquiry were fighting to expose, and that racism underlay the targeting of black justice groups seeking accountability for such police brutality and corruption. In June 2016, John was informed by officers from Operation Hearn that the campaign had been listed in the 1987 SBS annual report as one of the organisations that was directly penetrated or closely monitored during the year under review. He was informed that Operation Hearn could not find any of that intelligence, and most likely it was destroyed. The inquiry has disclosed to John a number of intelligence reports stretching over 9 years, the first of which is from March 1987, and in it, undercover officer Stefan Scott reported that a leading member of the Hackney Socialist Workers' Party had become involved in the organising committee of the Metropolis campaign, although he noted that she was somewhat isolated due to her colour and politics, and that the SWP had little influence over the policy and direction of the campaign. He noted the family's extreme distress, and that the campaign's primary objective was that truth and justice should be ascertained by way of the relevant legal processes. They will seek public support only in pursuing their objective, for example, an independent inquiry. Notwithstanding this assessment of the campaign very early on in its inception, it is clear it continued to be spied on for at least the next 9 years. The last intelligence report was in February 1996, and it concerned the preparations for the memorial which was to be held on the 2nd anniversary of Trevor's death. It was reported that this order was unlikely. John is aware that undercover officer Mark Jenner, under his cover name Mark Cassidy, had infiltrated the memorial tour that was held by the family on the 1st anniversary of Trevor's murder in March 1995. John considers that this was a gross violation of his family's privacy. His statement describes the pain caused to him, but even in death, the police did not leave Trevor and their family in peace. He believes the spying continued because the police wanted to know if they were getting any closer to finding out what happened to Trevor at the police station. His distress is exacerbated by the evident attitude of the police towards families such as his, and their view, which he believes is based on racism, that any campaign they were involved in might somehow be a catalyst for disorder or unlawfulness. John is particularly concerned that in this 1996 report, for the first time, the campaign has been given a special branch reference number. He seeks to understand why, after the intervening years in which the campaign had gone quiet, should it suddenly have been given the reference number when it had been reported from its inception that the campaign's primary objective was that truth and justice should be ascertained by way of the relevant legal processes. John notes that this report was prepared and reviewed by DCI Keith Edmondson a few weeks before the Metropolitan Police told the coroner at Trevor's resumed inquest that John could not be contacted. This was despite him living at the same address and still working in the shop he'd worked in for 30 years, with the result that he was not aware until August 2016 that the inquest into his son's death had been concluded on a single day in 1996. John is deeply shocked and saddened by what he considers to be a deplorable and gross double standard, whereby covert information is intrusively obtained, while there was no communication with the people who mattered most to Trevor, in particular concerning the judicial inquiry into his death. It has contributed to the total erosion of his trust in the police. In addition to the direct intelligence reports, John believes there is other clear evidence on which the chair should find that the Burke-Monerville campaign was directly targeted for surveillance by the SDS. Firstly, the Burke-Monerville campaign is listed as directly penetrated or closely monitored in the 1987 annual report. DCI Tony Waite provided a definition of the word penetrated found within the SBS annual report. He explained that one visit to the group was not enough for it to be considered penetrated. There had to be repeat reporting or attending. John hoped the chair would rigorously investigate the alarming hypothesis advanced by officers from Operation Herne that it was unlikely the campaign was directly penetrated because they couldn't find any of the intelligence that related to it, and that this entirely untrue assertion was made by senior officers in their annual report to the Home Office in order to make the SDS sound more important than they were to justify their work. Presumably, this would have been done in order to obtain continued or increased funding. The evidence of DCI document is that the SDS annual reports were designed to set out the justification for the SDS for the Home Office. This would appear to amount to misconduct. And while Operation Herne were apparently unable to find any intelligence reports relating to the campaign, the chair has been able to consider a number of reports demonstrating that continued to be reported on for 9 years, and which were not available to Operation Herne when its officers provided their startling explanation. John considers that in putting forward this explanation, the MPS were deliberately attempting to minimise the SDS targeting of the campaign and the racism behind that targeting, as they have done throughout all the significant events that he has recounted. John's concern as to why his family had been targeted was dismissed without investigation. He believes that the explanation proffered by Operation Herne officers was merely another instance of the MPS endeavouring to control the narrative of the event, so as to avoid scrutiny on and accountability for the racism that underlay them. Secondly, the absence of any evidence of public order or infiltration by extremist justification in the report. The only reference to public disorder in any report relating to the campaign is that it is unlikely. The MPS have accepted that no public order justification for spying on campaigns, such as that of the Burke-Monerville, can be legitimately relied upon. Reporting on justice and anti-racism groups who pose no criminal or public order threat should not have occurred, and they tell us would not occur today. Similarly, there are no intelligence reports indicating any infiltration by left-wing extremists. The fact that the campaign continued to be spied on for the next 9 years provides strong evidence that it was directly targeted. And thirdly, the practice of the MPS of reporting on anti-racist and police accountability groups in general. The inquiry has received multiple sources of incontrovertible evidence that the SDS targeted groups campaigning against racism and for justice and police accountability. The MPS have acknowledged the indefensibility of this discriminatory policing and its enduring problem of racism. Where, therefore, there is no public order or infiltration by extremist justification, and the MPS, an institutionally racist organisation, can be shown to exhibit an obsessive interest in any group perceived to be anti-police, why would the Trevor-Monerville campaign not have been directly targeted? The only explanation for the spying on the campaign is, like so many of the other non-state full participants to this inquiry, because John and his family were black people seeking justice and accountability for police brutality to their loved one, which in the view of the SDS senior officers made them suspect as anti-police and worthy of spying. Acceptance of this fact leads to the clear conclusion that the campaign was highly likely to be a direct target of the SDS for this very reason. Turning to spying on police accountability groups generally. The core aspect of the inquiry's remit is to examine the motivation for the undercover police operations, and the chair has acknowledged that he must examine the possibility that the deployments of black justice groups were influenced by conscious or unconscious racism. John Burke-Monerville urges the chair to recognise that racism as a motivation must be at the heart of his investigation. He joins with the many other core participants who have given and will give evidence to this inquiry of their lived experience of racism by the Metropolitan Police Service, to exhort the chair to recognise the fundamental role which the issue of racism played in the targeting of the SDS. Other non-state core participants to this inquiry have set out in detail the evidence of the history of the SDS, demonstrating that almost from its inception, it embarked upon sustained and wide-ranging infiltration of black political and social justice groups, and in particular black groups campaigning for accountability for police brutality, racism and corruption. The extent of the SDS penetration and the material revealed by the inquiry demonstrates that the police justification of collateral intrusion is not tenable. The MPS itself has acknowledged that spying on the anti-racism campaigns, which were attempting to hold the MPS itself accountable for the way in which it policed those communities, was particularly indefensible. In what can only be understood as an acknowledgement of the role that racism played in the surveillance of campaigns such as the Burke-Monerville, the MPS that such reporting was discriminatory and unacceptable political policing. The documents show the MPS's wide-ranging mistrust of any group that seeks accountability for police misconduct. All are swept up under the rubric of being anti-police, which of itself is considered a reason to spy on those groups. The extraordinary 1983 Police Accountability Report provides insight into the mindset, including, for instance, groups such as the charity Release, merely because, in light of their libertarian views, they can have little natural sympathy for the group. In 1984, the Home Office released the new Special Branch Terms of Reference, directing chief officers that it is not the function of Special Branch to investigate individuals and groups merely because their policies are unpalatable, or because they're highly critical of the police, or because they want to transform the present system of police accountability. However, it is evident that the SDS routinely continued for decades to investigate individuals and groups precisely because they're highly critical of the police or because they want to transform the present system of police accountability, which must have been evident to the Home Office from the annual reports. This is not mere institutional paranoia. It is the manifestation of a deep-rooted tendency built into the fabric of the MPS to cover up its wrongdoing and avoid accountability to the communities it serves, as institutional as the racism with which it is played. These groups were deliberately targeted in order to undermine them and their objective. This core aversion to accountability and scrutiny is intertwined with the endemic racist attitudes and assumptions evidenced by SDS officers to view those groups from the Black community with particular suspicion. Opposition to racism was of itself considered potentially subversive. John believes that the motivation of the police was a desire to derail and discredit the Burke-Monerville campaign, attempt to bring to light racist police brutality and harassment, as with other justice groups that were targeted. The MPS acknowledges that the fact that such groups were reported on was a critical failure on the part of the special branch managers. Police accountability groups were directly monitored so that the MPS could find out information that could be used to discredit legitimate campaigns and undermine their attempts to expose police wrongdoing. In John Burke-Monerville's case, this tactic took the form of dismissing and ignoring his legitimate concerns. In April 1987, Chief Superintendent Peck publicly apologised to John for the failure to tell him Trevor was being held in Stoke Newington Police Station, and then started the narrative that's continued to be adopted by the SDS in this inquiry, that he was concerned that the situation was being manipulated by political agitators. At the same time, however, the MPS were refusing to release Trevor's clothes to the family so they could be forensically tested. The MPS chose not to use its resources to investigate the corruption, racism and misconduct that the groups such as the Burke-Monerville campaign, specifically in relation to Stoke Newington police officers, were seeking to highlight, but chose to spy on them instead. Had they engaged in meaningful dialogue, the spurious purported public order justification could easily have been addressed by direct communication and without invasive intrusion and the huge waste of resources deploying undercover officers in this role over decades. It could also have transformed racist policing, saving years of significant trauma for many Black families in London, including the Burke-Monervilles. The research by the Public Policy Studies Institute, funded by the MPS the same year it produced its Police Accountability Report, provides incontrovertible contemporary evidence of the endemic racism that permeated the MPS. The use of racist language and racial prejudice amongst police officers in areas with substantial ethnic minority populations was found to be prominent and pervasive. The authors observed the use of crude, derogatory, racial terms of abuse as a standard practice amongst MPS officers, including in public and on police radios, and found that racist language and prejudice were on the whole expected, accepted, and even fashionable. They concluded there can be few other groups other than the Met in which it is normal, habitual, automatic to refer to black people as coons, niggers, and so on. Noting that when a police officer started on a line of racist talk, no one in the group ever exclusively opposed their views or made the officer feel as though he'd spoken inappropriately. The NPS have acknowledged the corrosive effect this type of discriminatory policing has on public trust and accepts that racism and discrimination remain an enduring challenge within. Baroness Casey's recent review of the Met found it continues to be institutionally racist. The Chair will consider in Module 3 the recommendations that should be made for the future. John Burke-Monerville were asked to put before the inquiry at that stage evidence that goes to the two key issues that spy on his family and other campaigns engaged: racism continuing to infect the NPS and the wholesale failure of the current process of police accountability. And just in conclusion, Mr. Burke-Monerville's hopes for the inquiry. Mr. Burke-Monerville has a profound need to discover the truth. He states, "I feel a responsibility to my sons, myself, my family, and my community to ensure that this inquiry comes through with some sort of answers about why we were spied on by the police. We have not been told the truth by anybody in authority about anything all along. I have no reason to be hopeful about this inquiry. No one in authority has given me that. But I do remain hopeful. It is, though, my last hope, and I am tired. I don't want my surviving children, grandchildren, and great-grandchildren to go through what we are going through." Mr. Burke-Monerville and his family have been truly failed by the Metropolitan Police Service in so many ways. He's experienced enormous personal tragedy, which he has borne with immense strength and dignity. He hopes he will not be failed by the inquiry in his search for the truth at this last opportunity. Thank you, Chair.
Thank you very much indeed. Next, I think, is Rajiv Menon, King's Counsel, for Richard Adams.
Good afternoon, sir. Can I just check that you can hear me clearly?
I can hear you very clearly.
I'm grateful. One of the defining features of British policing in the last 50 plus years has been its racism, a racism institutionalized within the structures, systems, policies, practices, and culture of British policing, a racism that has manifested itself in a multitude of different ways, including: 1, the over-policing, harassment, maltreatment, and stereotyping of ethnic minority communities. 2, the racially discriminatory use of stop and search powers. 3, the failure to protect ethnic minority communities from racist crime. 4, the excessive and disproportionate use of force against ethnic minority communities. 5, the woefully inadequate response to racist attacks. 6, the deliberate deracialization of racist crime. 7, the criminalization of victims of racist attacks as suspects and perpetrators. 8, the racially disproportionate number of deaths in police custody. And 9, the weaponization of immigration law against ethnic minority communities, asylum seekers, and refugees. Where then does this racist policing originate? How has it come to be so thoroughly embedded in our policing institutions? A quick look at the historical record provides at least one answer. A significant number of senior and rank-and-file police officers, notably after the Second World War, had previously been colonial police officers in India, Ceylon, Malaya, South Africa, Cyprus, Palestine, and elsewhere. During the 20th century, most Metropolitan Police Commissioners and many other senior officers had backgrounds in colonial or military policing, including Sir John Waldron and Peter Brodie, Commissioner and Assistant Commissioner respectively in 1968, when the Special Operations Squad, which later became the Special Demonstration Squad, was set up, who both served in Ceylon, and Sir Kenneth Newman, Chief Constable of the Royal Ulster Constabulary in Northern Ireland from 1976 to 1980, and Commissioner from 1982 to 1987, who served in Palestine. Colonial policing across the British Empire was characterized by racism, brutality, and unaccountability. Colonial police officers enforced racially discriminatory and authoritarian laws. They had paramilitary training and draconian powers, which they used often with impunity. They were rarely, if ever, held to account for abuses of those powers. Undercover surveillance, crowd control, and torture were commonplace. Order trumped law. Any challenge to British rule or British economic interests was sedition. In the circumstances, it is hardly surprising that colonial police officers returning home to join the police in Britain brought with them the racialized practices and political attitudes of colonial policing. During the 1980s, racist policing was arguably at its peak, given the racial inequality in British society and the role of the police in enforcing that inequality through racially differential political policing. The inner city rebellions of 1981 and 1985, at least in part sparked off by violent public order policing, were stark examples of that growing racial divide. Sir Kenneth Newman's reign as Metropolitan Police Commissioner was a particularly grim time, given his persistent targeting and blaming of the Black community, and specifically young Black people, for their opposition to racist policing and for the deterioration of public confidence in the police. But what about undercover policing? Did undercover policing miraculously manage to avoid being tarnished by the scourge of racism? Absolutely not. It is inconceivable that undercover policing was not blighted by the same racism that blighted every other area of policing. And yet this inquiry has barely considered the impact of racism on undercover policing thus far, and risks merely reproducing this blight. That, with all due respect, must end now. The racist murder of Roland Adams and the racist attack on Nathan Adams in February 1991, and the subsequent police spying on the Adams family and their supporters, provide an ideal focal point for this inquiry to address, at long last, the impact of racism on undercover policing and the failure of the undercover police to recognize or tackle the threat posed by the far right and racist criminal groups. They also raise important questions about police corruption and police involvement in organized crime. Roland was not killed in a vacuum. His murder was the tragic culmination of a decade of increasing racist and fascist violence in Southeast London. Racist murders had become an almost annual atrocity. The increase in racist violence coincided with the fascist British National Party moving its headquarters to nearby Welling in 1989. The police, including the undercover police, had failed to combat these crimes in a meaningful way. Indeed, for many in the Black community, the police were very much part of the problem as opposed to a part of the solution. In 1991, Richard and Audrey Adams and their 3 children, Roland aged 15, Nathan aged 14, and Lauren aged 6, lived in Abbey Wood, southeast London. Richard was a station supervisor at Blackfriars Station. Audrey was a pensions manager at the London Borough of Lewisham. An exceptional woman, she was so keen to give evidence to this inquiry and tell her story, but sadly passed away in February this year. Could we please have the photo of the Adams family of Richard, Nathan, Lauren, and Roland taken in 1988 on the screen, please? I'm grateful. On the 21st of February, 1991, Roland and Nathan played table tennis at Hawksmoor Youth Club in nearby Thamesmead. They left the club and waited at the bus stop to go home. A gang of about 12 to 15 white youths saw them and chased them, some shouting racist abuse. Almost immediately, Roland was fatally stabbed in the throat with a butterfly knife. He started to run, shouting at Nathan to run too. That is how they became separated. Nathan was chased around Thamesmead but managed to escape. When he returned to the scene, he found his brother dying. Roland and Nathan were not the first black boys to be brutally attacked in the area. Several others had been hospitalized in the months leading up to Roland's tragic murder. There had been a dramatic increase in racist attacks in the area in recent years. This has been well documented by, amongst others, a local community group, the Greenwich Action Committee Against Racial Attacks, GACARA, and also by Greenwich Council's Racial Equality Committee. The attack on Roland and Nathan brought to a head simmering racial tensions and violence, as the attackers were amongst those who had been regularly terrorizing the local black community. Some called themselves the Nazi Turnouts, NTO, a group also described as the KKK or the Goldfish Gang, and identified by some as something of a British National Party youth group. The NTO used to congregate outside the off-license next to the Wildfowler pub, which was near the Hawksmoor Youth Club. The Wildfowler pub was a well-known meeting point for BNP members and a local center for drug dealing. After Roland's murder, it came to light that a youth leader at the Hawksmoor Youth Club had become increasingly worried about increasing racist violence in the area in the months prior to Roland's murder. She had raised the matter with the police and Greenwich Council, however, neither had taken appropriate action. Richard Adams believes with good cause that had there been effective policing of these earlier attacks, and had the threat posed by the BNP and racist criminal groups been recognized and tackled, the attack on his sons might have been prevented. As it was, the attackers were already known to the police, so it was easy for the police to identify and arrest them. However, most of them were bailed and continued to cause problems. From the very outset, neither the police nor the Crown Prosecution Service would accept that Roland's murder was racially motivated. They de-racialized the crime and mischaracterized it as a fight over territory. This has been an age-old problem that victims of racist crime have had to endure, namely a refusal by the police and other public authorities to recognize the racist motives and intentions of racist perpetrators. The police branded Roland and Nathan with the racist stereotype that black boys cannot be innocent. Nathan was ill-treated by the police. Although he too was attacked, nobody was ever prosecuted for assaulting him. Within weeks of Roland's murder, and for the first time in his life, Nathan started getting harassed and criminalized by the police. He was regularly stopped and searched in the street. He was detained and charged. He was told that he was banned from going to Thamesmead. Of the white youths arrested for Roland's murder, only Mark Thornborough was charged with murder. He stood trial and was convicted. Despite the prosecution de-racializing Roland's murder, the trial judge summed up the case on the basis that the murder was racially motivated and sentenced Mark Thornborough accordingly. This was the first official recognition by the state that the murder of Roland Adams was a racist attack. Given the general willingness of the police and the CPS to use the principles of joint enterprise to prosecute as many members of a group as possible on the basis that they assisted or encouraged violence, why did such willingness dissipate when it came to the prosecution of the racists who murdered Roland? The failure to prosecute any of the other attackers with murder is indefensible. After Roland's murder, and in the face of a lack of support from the police and the local authority, Audrey and Richard, together with relatives and friends, formed the Roland Adams Family Campaign to secure justice for Roland. Over the years, the family campaign grew, reaching out to other victims of racist violence and racism. It also played an integral part in efforts to shut down the BNP headquarters and bookshop in Welling. Maybe Mark Thornborough's trial judge learned something about the true nature of Roland's murder from the efforts of the family campaign. Could we please have at this stage the leaflet of the Roland Adams Family Campaign on the screen? Thank you. This is one of many leaflets produced by the Roland Adams Family Campaign, this one advertising a march on the 27th of April, 1991 from Hawksmoor Youth Club in Thamesmead. I'm not going to read out the entire leaflet, sir, because of the time I've been allotted, but you'll note the headlines. Unity is strength, nothing can stop us from walking the streets, and the struggle continues. Thank you. That leaflet can be taken down. The police were hostile to the family campaign. For months after Roland's murder, the police stopped friends and relatives who came to visit the family, never explaining why. Richard Adams remembers the family liaison officer, P.C. Fisher, visiting the family home unannounced, showing empathy that did not feel real, and trying to tease out information from the family. Meanwhile, the Adams family were receiving threatening calls, with some callers gloating about Rowland's murder. They were getting harassed, as were their friends and relatives. So bad was the harassment and so absent was any police protection that the Adams family were advised by the local authority and the local Commission for Racial Equality that they were in danger. They were told to leave their home that night. This they did, just 3 months after Rowland's murder, and whilst they were still in dreadful shock and mourning. The Adams family asked the inquiry to consider whether, if undercover police activity had been focused on the racists and not on themselves, the family could have been kept safe. In the 33 years since Rowland was murdered by racists on the streets of London, the pain, grief, and anger of the Adams family have not diminished. They are angry that only one of Rowland's killers was prosecuted and convicted of murder, with 4 others given community service for minor public order offenses. They are angry at the culture of denial that has seen Rowland's racist murder largely airbrushed from history. They are angry about today's knife crime crisis that they believe is a manifestation of the police targeting Black youths in the aftermath of increasing racist violence in the 1980s and 1990s. They feel let down by the police, the justice system, and politicians. They believe that if the police had taken decisive action following Rowland's murder to tackle racist violence in the area, if the police had turned their intelligence gathering away from them and onto the racists, it is possible that the police could have prevented other racist attacks and murders in the area. They ask whether, for instance, the life of Rohith Dougal, murdered in a racist attack in July 1992, could have been saved. They ask whether, for instance, the racist murder of Stephen Lawrence and the racist attack on Dwayne Brooks in April 1993, which happened in very similar circumstances just a few miles away in Eltham, could have been prevented. And whilst they note that there have been some advances since the 1990s, and racism is taken more seriously in some circles now than it was then, they believe that institutional racism remains endemic in our society and that there remains a toxic culture of racism, one that is more covert and sophisticated than it was 30 or 40 years ago. It is a culture that is even more ominous when it is the culture of those who have power over us, such as the police, operating undercover and hidden from public scrutiny. Richard Adams demands an explanation as to why the police spied on his family, given they were parents who had lost a child and were law-abiding citizens who simply wanted justice for their murdered son. Whether the family campaign was directly targeted for infiltration by the police or indirectly targeted because of its association with other anti-racist groups is neither here nor there. We trust that the inquiry will not be distracted by this red herring. The family of a young boy murdered in a racist attack, who posed absolutely no threat to public order, should never have been spied on by undercover officers. It is disgraceful that they were. Richard questions whether the police would spy on a white family in similar circumstances. Richard would like to add that he and Audrey long believed that they were spied on. Over the years, they had taken steps to limit the intrusion. For example, they stopped using the landlines they thought were bugged. They had nothing to hide, but they had their privacy to protect. When they raised the matter with several agencies, they were made to feel as if they were paranoid and stupid. Confirmation of their fears leads them to ask on whose side is the criminal justice system. They want answers just as much as the inquiry wants answers. They want to know why the SDS was spying on them and not infiltrating racist criminal groups in Southeast London, given these groups were a clear and obvious public order threat, extremely violent, subversive, and politically dangerous. As Richard Adams states in his heartbreaking and thoughtful witness statement, which we commend to the inquiry, Rowland was, in his words, quote, slaughtered by racist society, end quote. We must never forget that. Furthermore, we must never forget that the treatment of the Adams family by the police and the prosecuting authorities is emblematic of how our criminal justice system can dehumanize Black people and Black families. That it should include undercover surveillance of the family of a boy murdered in a racist attack heightens the urgency of this inquiry, unequivocally condemning the police for spying on the Adams family. We note the Metropolitan Police Service's belated apology today to the Adams family for the indefensible scrutiny into their lives. We welcome the apology, even though it is more than 30 years late and remains to be given to the family personally. We invite the Metropolitan Police Service to give the apology substance by urgently disclosing any information about the undercover policing or lack of it of racist criminal groups in Southeast London in the 1980s and 1990s, and about any use made of information gathered by police officers purporting to support the Adams family in their time of bereavement. In conclusion, sir, having considered the limited disclosure that they have been provided by the inquiry, the Adams family are puzzled and angry that they know little more now about the nature and extent of the undercover police spying on them than they did when granted core participant status in 2019. They are puzzled and angry that the inquiry appears uninterested in investigating the nature and extent of undercover police spying on racist criminal groups in Southeast London, given it was members of one such group who killed Roland and attacked Nathan. They are puzzled and angry that the inquiry to date has refused to investigate the use of information obtained about the family by their family liaison officer, even though the inquiry has accepted that such an abuse of status can fall within its terms of reference. They are puzzled and angry that the inquiry has only called one undercover officer in an open hearing who infiltrated the far right, namely HN56, and he, for some inexplicable reason, was deployed to infiltrate a largely inactive BNP branch in Loughton, Essex. They are puzzled and angry that they are none the wiser about the nature and extent of undercover policing of the far right more generally, and will remain none the wiser, given this is apparently to be considered in secret hearings from which they, all other non-state core participants, and the public are excluded, and given the inquiry has thus far forbidden any questions being asked of any police witness in open hearings about the nature and extent of police spying on the far right. They are puzzled and angry that the inquiry has not provided any adequate explanation as to why such an extraordinary course of action is being taken in what is supposed to be a public inquiry into undercover policing. On behalf of the Adams family, we ask the inquiry to reconsider its approach to the undercover policing of the far right and racist criminal groups, and provide the non-state core participants with a proper explanation for all this secrecy. Otherwise, effective participation in the inquiry is being denied. Thank you.
Thank you very much. May I make two observations to you and to the family that you represent? One observation to you and to them, and then another matter entirely. As the inquiry has stated, right-wing groups were the subject of infiltration by the undercover police unit between the 1980s and the closure of the unit. However, for reasons that I would hope would be obvious to those that you represent, those deployments have got to be considered in closed session. I'm not asking for a response to that. I've heard what you've said, but I want those behind you in particular to understand the reasons for the inquiry's approach. The second concerns another matter entirely. I know you have another opening submission to make to me tomorrow on behalf of a separate group. Could I ask you to reconsider paragraph 8 of that submission, that written submission, when I believe you have made a mistaken identification?
I will look at that overnight, sir.
Yes.
And I won't respond to the point about the far right. You know what our submissions on that are, and I don't think I need to repeat them.
No, indeed not. No, your position is very clearly stated. I hope that those behind you understand the position of the inquiry, which I have repeated on a number of occasions now. But thank you very much indeed for the economy with which you've made your opening submissions. I'm grateful to you. Thank you. The time is now 10 to 3. We will resume, I hope, at 3:05 with Charlotte Kilroy for the Category H participants. Ms. Kilroy.
Sir, I appear on behalf of the Category H call participants. They are women who were deceived into sexual relationships by undercover officers. There is evidence before this inquiry that at least 17 women were victims of this abuse in the 10-year period between 1983 and 1992. The true number is likely to be higher. Two of these women, B and Jenny, gave evidence in July about being deceived into sexual relationships by Trevor Morris. Today, I'm going to focus on what happened to 4 more women. Their names are Belinda Harvey, Helen Steele, Denise Fuller, and a woman known to this inquiry as Jessica. They are due to give evidence in November, December, and January. The officers who abused them are Bob Lambert, John Dines, Andy Coles, and HN1, cover name Matt Rayner. I will also set out some key questions which the Cat H call participants consider the inquiry must investigate and answer. This is in order to identify all the factors which underlie the misconduct of these officers. Only in this way will it be possible to ensure that the abuse and damage which these women have suffered will never be repeated. The Category H call participants have produced a written opening which addresses these issues in more detail. So, as you've already heard this morning, married 32-year-old undercover officer Bob Lambert had sexual relationships with at least 4 women during his deployment for the SDS. He made one of them, Jackie, pregnant, and in 1987 had a child with her, TBS. It was after this that he started a relationship with 24-year-old Belinda Harvey. Belinda was not an activist or a member of any group in which the SDS was interested. She wanted a career and family and had a job at the Electricity Board. After they met at a party in April 1987, Lambert kissed her the same night, and there immediately followed a cascade of romantic letters and gestures. Within days, their sexual relationship had begun. He repeatedly declared his love for her and made her believe she had found the man she would spend the rest of her life with. Because he appeared to be such a committed anti-capitalist and animal rights activist, she altered the way she lived to fit him. She drifted away from her non-activist friends and abandoned her plans to be an accountant. He encouraged this. He even invoked his pretend views on animal rights to dissuade her from buying a flat above a fried chicken shop. For almost 2 years, he carefully nurtured her passion for him, playing the part of a devoted lover, including with holidays and visits to friends and families. But in December 1988, Bob said he had to go on the run from the police to Spain, and that it was too dangerous for her to come too. He then disappeared from her life forever. She initially collapsed from the heartbreak and then continued to hope that Bob would send for her or return. It took 20 years before she found out all this was a lie. For the last decade, she has had to face the pain and trauma of knowing that Lambert literally played with her. He conjured in her that most sacred of human feelings, love, and trampled on it. He treated her personal life like a fantasy game world in which he could pull strings and press levers and see what happened, satisfy his own emotional and sexual desires, and then exit when he had finished play. He did all this with SDS managers looking on. They knew he had made another woman pregnant while undercover and that he had had a baby, and they still did nothing to stop his relationship with Belinda, which they also knew about. It is clear that for the Metropolitan Police and SDS management, as for Lambert, Belinda's life and body had little value. She was a price worth paying to maintain the SDS and to humour the whims of a man who mattered far more than she did. In 1987, Lambert's close SDS colleague, 32-year-old married undercover officer John Dines, befriended environmental and social justice campaigner Helen Steele. It appears that Lambert suggested Helen as a target. At 22, she was 10 years Dines' junior. Despite her youth, he conceived a plan to seduce her. Dines believed that a long-term sexual relationship with Helen would bring a range of benefits. It would make it easier to obtain information and infiltrate various groups. It would also enhance his status and career in the SDS. Dines mounted an elaborate campaign over several months. He offered her lifts home in his van, dropping her off last. He told Helen both his parents had died when in fact they were still alive, and even pretended to go to his mother's funeral. Dines staged his own arrest to gain her sympathy. Once she had finally succumbed to his advances in May 1990, he bombarded her with love notes. Using some of the tactics honed by Lambert, he spent the next 2 years doing everything in his power to cause her to fall deeply in love. He told her constantly that he loved her. He discussed buying a home, having children, and spending the rest of their lives together. They lived together for a year. She believed she had found her soulmate and that they had an idyllic life. He now tells this inquiry that he did all this solely to gather intelligence and that back office knew. He also says he had to make her have feelings for him, although in fact, as he puts it, he didn't give a rat's. His support for her during the grueling McLibel proceedings was no more than a ploy to gather privileged legal information. Dines' cruelty did not end there. When the end of his deployment approached, he started to claim that he was having a mental breakdown. What followed was a drawn-out process of repeatedly leaving Helen and then reappearing in her life once again, professing deep love and commitment. He continued in this erratic pattern even after his deployment ended in December 1991, before finally disappearing forever in what seemed to be a distressed state, to what he said with South Africa in spring 1992. Helen was extremely distressed and spent years looking for him. She did that because she believed his state of mind might have led him to some harm. Her attempts to find him came so close that Dines sought the SDS's assistance. They went so far as to move him and his family to Australia, but they took no steps at all to protect Helen or compensate her for Dines' abuse. That abuse has continued with Dines' evidence to this inquiry. Not only does he assert without shame that he only entered the relationship to gather intelligence, he also demonstrates no remorse at all for his treatment of Miss Steele. Indeed, he is proud of it. He has filled his statement with personal insults against her and malevolent false allegations. It is impossible to avoid the conclusion that his evidence is designed to wound her still further. How a man with so little empathy for other human beings and so much hatred for women came to be let loose on the British public is a matter of grave concern. It merits close examination. Sir Dines' unabashed cruelty is matched only by his towering cowardice. He has refused to give oral evidence to this inquiry. Both for that and for his conduct, he deserves contempt. Helen thought her relationship with Dines was based on love, mutual respect, shared values, and common interests. Discovering that the person she loved and thought she knew best didn't actually exist was a profoundly disabling experience and permanently harmed her ability to trust others and even her own judgment. Married undercover police officer Matt Rayner, as he was known, considered the SDS the crown jewels of policing and joining it a badge of honour. His view was that, to quote him, no code of conduct could substitute for the sound judgment and integrity of individual officers. He says he was actively encouraged to build relationships and an authentic persona that would endure for a period of years. Accordingly, he had a relationship with Denise Fuller for over a year. Rayner states that his managers were aware of the relationship and did not tell him to stop. Denise has significant health concerns. Rayner used them as a way of gaining her affections. After a particularly challenging time in her life, he came to her house to comfort her. His sarcastic reports about this time to his colleagues reveal his true attitude, but Denise believed in his sincerity. Shortly afterwards, they began a sexual relationship. He says he discussed it with Lambert and that Lambert described it as a test. The sexual relationship lasted well over a year until 1995 and involved them spending 3 or 4 nights a week together, going to the theatre, the cinema, taking walks on the heath. With him, Denise became more involved in activism than she otherwise would. Rayner reported continuously on Denise before, during, and after their relationship. She describes him as being jubilant about the access to other activists which the relationship gave him. He accepts that the relationship countered doubts about his credibility. Denise ended the relationship when she went to university. Rayner tried to rekindle it. Rayner has succeeded in concealing his real name from both Denise and the public. His ability to maintain privacy for himself, when with the knowledge of SDS managers and others, he tricked his way into the most private part of her life and defiled her bodily integrity, is a continuing injustice to her. It has worsened the already severe impact which Rayner's conduct and the pressure of engaging with the inquiry has had on Denise's well-being. It emphasises that her rights come second to Rayner's, even when she has been the victim of a wrongdoing as serious as this. When he was 32, but posing as a 24-year-old, married police officer Andy Coles started a sexual relationship with 19-year-old Jessica. Jessica was vulnerable after a childhood blighted by personal tragedy. She had never had a boyfriend. Coles got to know Jessica by inviting himself around to her house share and just hanging around. He was, on his own account, unattractive. He says that in his undercover persona, he neglected his personal hygiene and wore unflattering clothing. One night, he lunged at Jessica while they were watching TV. She was shocked, but did not want to hurt his feelings. Her youth and lack of confidence meant she found it easier to go along with a sexual relationship she did not really want than resist his advances. The relationship lasted for a year. It was lacking in affection on both sides. For Coles, it seems to have been chiefly a source of regular extramarital sex with a teenager. When Jessica went to France for a period of time, he went so far as to complain that her absence meant he should be able to see other people. Jessica eventually ended the relationship when she gained the confidence to realize she did not have deep feelings for Coles. Before, during, and after the relationship, Coles reported on Jessica. He has since risen to high ranks within the police. He went on to be a head of training for ACPO and then Deputy Police and Crime Commissioner. He now denies the relationship. He says instead that Jessica was obsessed with him and pursued him with sexual advances, which he continuously rebuffed. The Cat H call participants submit that Coles's evidence is implausible and Jessica's is far to be preferred. They note also that another woman has given evidence that Coles lunged at her in a manner similar to the way in which he began his relationship with Jessica. Coles's denial of his relationship with Jessica is not the only dishonest evidence he has given to this inquiry on the subject of sexual relationships. Coles is the author of the Tradecraft Manual, a dossier of advice for undercover officers which circulated for years within the SDS. He wrote it at the request of Lambert at the end of his deployment in 1995. In that manual, Coles provided advice on sexual liaisons, in which he acknowledges that romantic and sexual relationships have occurred on numerous occasions before, causing all sorts of difficulties. Consequently, he states that, to quote, "While you may try to avoid any sexual encounter, there may come a time when your lack of interest may become suspicious, and you must make up your mind how to proceed. In that situation," he advises, "if you have no other option but to become involved with a weary, you should try to have fleeting, disastrous relationships with individuals who are not important to your sources of information." Coles now says in his statement to this inquiry that he was not suggesting in this passage that field officers should have a fleeting, disastrous sexual relationship, but a fleeting relationship that did not include a sexual relationship. This suggestion is impossible to reconcile with the context of the paragraph and is obviously false. Equally false is the claim that the policy was really clear and "I thought it was widely known that sexual relationships were not permitted." The evidence of Lambert, who commissioned the Tradecraft Manual, and Dines, who trained Coles, is to the opposite effect. They both say sexual relationships were considered necessary in certain circumstances and permitted. As for the claim that Coles only knew about one other undercover officer having a sexual relationship, Mike Chitty, this claim is also impossible to reconcile with the text of the Tradecraft Manual. Jessica discovered that Coles was a police officer in February 2017. Since then, her mental health has suffered enormously. She has developed paranoia. Her relationship of 10 years ended a couple of months later. It also made her relationship with her parents difficult while they were still alive. It caused significant distress to her father during the last years of his life. So there were a series of other undercover officers who had sexual relationships. You have already heard evidence about 35-year-old Trevor Morris, who was recruited by Lambert. In his undercover persona, as a 30-year-old DJ, Bobby Lewis, Morris went on to have 2 sexual relationships with Bea, a young mother, and Jenny. He gave evidence that these relationships were justified for what he described as his alter ego. He vigorously rejected the invitation to apologize for them and called the commissioner's apology outrageous. There were more. Mike Chitty had a relationship lasting nearly 2 years with Lizzie. He says that it was impossible to be in the field and not to have a relationship, and that SDS management would have known about officers having relationships in the field. He also had a relationship with at least one other woman. Another woman was deceived into kissing and oral sex by HN12, cover name Mike Hartley. HN67, cover name Alan Bond, has admitted to a one-night stand. Another officer has given evidence that HN67 told him he had fathered a child. HN87, cover name John Lipscomb, has also admitted to sexual activity with a woman while deployed. HN95, Stephen Scutt, is alleged to have had an affair with a woman in the group he infiltrated, and he has made an allegation that another UCO had had an affair while deployed. It appears that there is also an allegation that a closed officer had a sexual relationship in this period. These are just the relationships that are known about. In short, it is clear that between 1983 and 1992, police officers in the SDS were engaging in sexual relationships with women while undercover on an endemic basis. So the Category H core participants consider that the evidence is crystal clear that the fact that these relationships were occurring was widely known by other undercover officers and by managers. Their denials of knowledge are not credible and should be rejected. It is also clear that no one considered it necessary at the time to take any steps to stop these relationships. This was not simply turning a blind eye, although that would have been bad enough. The eyes were wide open, and still nothing was done. No consideration was given to protecting members of the public, even when managers were informed that children were being born of these relationships. Women were treated as disposable objects, their bodies and emotions derided, laughed at, and disregarded. The inexorable conclusion is that sexual relationships were considered part of the job and acceptable as long as there was no risk to the SDS and its operations. The inquiry will hear from 3 detective chief inspectors. They were the most senior managers in the SDS. DCI Waite was in charge during the deployments of HN 67, HN 12, Chitty, and Lambert. He says he was informed by Lambert that a woman with whom he had been having an association was pregnant. He was having an affair with a married woman in his undercover identity. He says Lambert later suggested the child might not be his. DCI Waite was content with this reply, he says, and spoke about it with Lambert no more. He also says, I and the other SDS managers were against such sexual relationships, but were unable to enforce this as the officers operated on their own. However, I would describe the SDS management's attitude to such relationships as one of acceptance. They worked on their own and made their own decisions. They were mostly married men, and it was not generally a problem. It is striking that despite DCI Waite's admission that he was told about the relationship and the pregnancy by Lambert, Lambert claims only to have informed DI Barber, who is dead. DCI Waite's evidence is thus significant in 2 ways. First, it means at least 2 managers knew that Lambert had impregnated a woman in his false identity and that he had had a child. It also means they did nothing about it. They not only let him continue in the field, but they allowed him to have further relationships. They then permitted him to exit his deployment without either he or the SDS taking any responsibility for that child or indeed any further children. It is not possible to overstate how reprehensible this conduct is on the part of all involved. It was morally bankrupt and rooted in deep misogyny. It was also a breach of every contract which the police have with the society whose well-being they are supposed to be safeguarding. The second significant aspect of this evidence is Lambert's failure to admit the conversation with DCI Waite. This is an example of a consistent pattern in this inquiry. In order to comply with the powerful internal code of backing up their fellow officers, only those officers who are either dead, have admitted relationships themselves, or are already damaged goods in some way, are implicated in wrongdoing by other officers. In short, SDS officers at all levels are giving dishonest evidence to this inquiry because they are prioritising the code of backing up over the public interest in discovering the truth. DCI MacLeod was in charge during the deployments of Chitty and Lambert. He told Operation Hearn that refusing a sexual relationship might lead to an undercover officer's compromise. He says an undercover officer's objective was to get the intelligence, not make moral judgments. In his Operation Hearn statement, he said, in terms of relationships between a field officer and their compatriots within their target groups, it is obvious that the closer a field officer got to the key people, the better the intelligence was likely to be. There may be occasions where relationships formed with women within the group and sexual relationships followed. This is not something a field officer would discuss with his supervising officers, but it has to be accepted that such liaisons will form. Although I was never aware of any sexual relationships between any of my field officers and Awiri, it certainly wouldn't have surprised me if it had occurred. The field officers all knew the boundaries and were left to use their common sense when deployed. Extramarital relations occur in all walks of life, and the field officers are no exception. I do not believe that we should be setting a moral code for one specific group of police officers to the exclusion of others. This has to be a personal judgment by the officers. In his evidence to this inquiry, he tries to distance himself from these remarks and says the sexual relationships have left him shocked and angered, and that it did not cross my mind that a close relationship might develop into a sexual relationship. DCI Docker was in charge during the deployments of Lambert, HN87 and Dines. He says that he formed a vague suspicion that there was the potential for sexual relationships between undercover officers and those with whom they interacted or associated in their undercover identities. He denies being aware of any sexual relationships, but he does accept that the merest hint of an affair would have become gossip in the male-dominated environment of the SDS. He does not accept he could have done anything differently to prevent sexual relationships from occurring. In fact, he considers that challenging undercover officers would have undermined the trust that we, as managers, had to have in the UCOs. He says the matter would not have been raised with undercover officers, save that DCI Waite might have said, "Keep it in your pants." DIHN 109 was second in command during the deployments of Lambert, HN 87 and Dines. HN 109 denies awareness or suspicion of any sexual relationships, although it is clear from his evidence that he appreciated there was a risk. In his Operation Sparkler interview, he refers to the high standards of intelligence being gained from horizontal politics. He now denies that this was a reference to sexual relationships. The Category H call participants do not accept that DCI's McLeod and Docker and DI HN 109 did not know about the sexual relationships happening on their watch. The inquiry has also received evidence from 5 detective sergeants who staffed the back office of the SDS. HN 45 says he was unaware of any sexual activity while deployed. There were no complaints or suspicions that were discussed in the office. HN 32 says he was unaware of any SDS officers having a sexual relationship in their undercover identity. DS Hyde says that when he first heard about sexual relationships undercover, he was taken aback and couldn't believe it. In his first statement, however, he also said that a sexual relationship entered into for seeking intelligence was a different ballgame to a sexual relationship because the undercover officer is attracted to that individual. Where it was based on attraction, DS Hyde did not think the relationship would need to be reported. DS Carson says he learned about Dines' relationship with Miss Steele subsequently, denies any knowledge of Jessica's relationship with Coles, and was surprised to learn of Trevor Morris's relationships. DS Hoochin says he did not suspect sexual activity undercover. He says he only learned about Dines' relationship with Helen Steele from news reports. Sir, the Category H call participants do not accept these denials of knowledge. SDS undercover officers and detective sergeants had close relationships. They all attended the Safe House meetings where undercover officers met twice a week. The sergeants must have been party to the constant stream of misogynist banter which took place at these meetings, and they clearly read the officers' reporting, which contained lewd and derogatory remarks about women. Consequently, these denials are not plausible. They are also not consistent with the evidence of undercover officers like Dines, who expressly say that back office knew of his relationship. Sexual relationships were common and were considered inevitable, acceptable, and useful in the SDS. It is extremely unlikely that these sergeants knew nothing about what everyone else in the SDS knew. They should start telling this inquiry the truth, and they should do it now. Sir, the Commissioner for the Metropolitan Police accepts that at least 9 SDS undercover officers had sexual relationships of one sort or another with women between 1983 and 1992, and we've heard that acceptance repeated this morning. He accepts that these relationships were a gross violation of the women's dignity and human rights, and he rejects the widespread denials of knowledge by SDS managers. Finally, he acknowledges that there was a culture of sexism and misogyny in the Metropolitan Police, which manifested itself in, as he put it, again today, the prevalence of sexual misconduct on the part of SDS officers in the Tranche 2 period, the general disregard for the personal autonomy and dignity of the women affected, together with the inaction or indifference of their managers in response. He apologises on behalf of the Metropolitan Police. The Category H call participants welcome these apologies and admissions. They do not think it should have taken this long to make them. So the evidence about the way in which undercover officers behaved towards the women they deceived into sex raises further difficult and uncomfortable questions. These questions go beyond the misogyny and sexism of the police and the culpability of individual undercover officers and SDS managers. It is essential, in their view, to address these questions if the inquiry is to fulfil its terms of reference and understand the risks of long-term surveillance operations. First, while misogyny and sexism was a key cause of the willingness of undercover officers to deceive women into sexual relationships, and also of the manager's tolerance of this conduct, this alone cannot explain the way in which the undercover officers behaved. What happened to Bea, Jenny, Belinda, Helen, Jessica, and Denise, and the other women who were deceived, has a further sinister and disturbing dimension. It is clear that when undercover, officers felt themselves liberated from a wide range of ordinary moral codes and restraints which would normally govern their conduct with others. They did not just tell lies which could be said to be necessary for their legend and deployment. They indulged themselves in a wide range of fantasies, apparently untrammeled by any sense of moral or ethical responsibilities towards other people. Given the chance to act out an imaginary character, they also took the opportunity to play with the lives of those with whom they had sexual and other relationships. They toyed with their victims' feelings. They often wielded the extraordinary power they were given with breathtaking cruelty or recklessness. Some officers, like Lamberts and Dines, manipulated and groomed their victims, Belinda and Helen Steele, to secure their deep love. They did this to enhance their cover and obtain intelligence. They also seem to have done it for the sheer pleasure of sexual and emotional manipulation. Sir Lambert and Dines used Helen Steele to boost their careers with their claims of access to intelligence from what they said was a high-value source. They justified their deployments with fabricated or embellished stories about her, and Dines lined his pocket with overtime claimed at her expense. She was for them the golden goose. As we have heard already, Dines has gone so far in evidence to this inquiry as to actually boast that he used Helen Steele's body and trashed her emotions purely to gather intelligence. His continuing cruelty to her is deeply disturbing. Other undercover officers, like Coles, Rayner, and Trevor Morris, developed techniques for exploiting vulnerable or very young women. Their experiments with these women have left a trail of emotional devastation which continues to reverberate up until the present day. So it should have been obvious that ordinary rules of conduct and ordinary supervision would not have been sufficient to counteract the danger posed by deploying undercover officers long-term in communities. They would not have been sufficient, even if those ordinary rules had been clear and properly implemented, which they weren't, and even if the Metropolitan Police had not been dogged by long-term misogyny and sexism. Fixing these problems is necessary, but it is not enough. That is because ordinary professional rules of conduct and supervision supplement moral constraints and supervisory mechanisms which are already present in communities and families. Those underlying restraints provide a baseline, and family and community supervision provides a ready-made safeguard. Police conduct codes and professional supervision operate on top. The evidence shows that undercover deployment in alternative personae, on the other hand, had the effect of releasing officers from the moral constraints and supervision applied by their communities and families. It thereby unleashed a range of dark behaviour for which the men faced no real consequences. It is true that they were protected by the SDS and enabled by misogyny, both of which permitted and even encouraged men to behave in this way. It is also true that with the eyes of their communities, families, and friends not on them, they let their worst selves out. The Category H call participants have paid a heavy price. The serious dangers inherent in the adoption of alternative identities away from ordinary community structures means such long-term deployments are unlikely ever to be appropriate. They certainly could never be justified in the context in which they were used by the SDS. The responsibility for failing to recognise the danger lies not only with the SDS, but also with higher echelons in the Metropolitan Police Service, the Home Office, and MI5. All of these institutions should have been aware that by permitting this highly experimental form of surveillance, they were also experimenting with the lives of the general public. It is deeply concerning that they either were not aware or did not care enough to avoid the obvious dangers. They must now learn the lessons of what went wrong. So it is clear they have not yet learned those lessons. In his written opening statement published today, and in his comments this morning, the Commissioner suggests that the SDS's infiltration of what he describes as the militant aspects of the animal rights movement was justified, but marred by the misconduct of its officers. He also suggests further justification comes from the evidence of witness Y for MI5. This is wrong. It indicates the Commissioner still does not appreciate the serious inherent risks involved in these kinds of long-term deployments. Such deployments are too intrusive and too dangerous ever to be justified in this kind of context. The second troubling matter raised by the evidence is the fact that it is clear that despite the Commissioner's apology and admission, many undercover officers and managers continue to conceal their own sexual misconduct or that of their colleagues. To this day, they feel little or no remorse or empathy for the Category H call participants. Many of them persist, like Rayner, in regarding the STS as the crown jewels of policing. They reserve their strongest condemnation for certain individuals in the police who have, as they put it, besmirched the SDS with their disclosures about it. More than a few are not providing honest evidence to this inquiry, as I've already stated. The misogynist and sexist views of many undercover officers and managers, which underlay the mistreatment of the Category H call participants, persist in the slurs and insults they make in their evidence to this inquiry, which only adds further salt to the wounds of their women victims. In addition, the long-standing culture of backing up, which requires police officers to cover up for each other, even where there has been wrongdoing, continues to take priority over the public interest. The Category H call participants consider that identifying and eliminating this backing up culture must become a Metropolitan Police goal alongside the elimination of misogyny and sexism. It is particularly important to do so for undercover work, where the risks of abuse are so much higher than ordinary police work. The police must be constantly reminded that they are here to serve the public interest, not each other. Those who prioritise each other over the public interest should face the most serious consequences. Thirdly, the role of MI5 in soliciting and perpetuating the conduct of undercover officers which led to the abuse of women must be properly acknowledged. MI5 were eager and appreciative consumers of SDS intelligence, even though much of it was of minimal importance to national security. They must have been aware of the tactics used. Their encouragement played no small part in causing undercover officers to believe that they were domestic James Bonds. The fact that a fictional serial womanizer and lawbreaker was seen as an inspiration for undercover officers in the SDS is plainly a matter of huge concern to the Category H core participants. They invite the inquiry and the Metropolitan Police to take all necessary steps to eliminate this harmful stereotype. James Bond belongs in books and movies and only there. In truth, SDS officers, with their newly grown beards and dressing up clothes, were more like the 1970s cartoon character Mr. Ben than James Bond. There is no doubt, though, that many revelled in the perception that they were a secret and reliable source. The idea that they could, like Mr. Bond, play fast and loose with both women and the rules seems to have been a powerful fantasy for more than one undercover officer. Finally, the Category H core participants wish to highlight the profound trauma that the process of engaging with this inquiry has caused them. There was always going to be trauma in the need to read and respond to the evidence of the officers who abused them and to confront their abusers in hearings. But this inevitable pain has been compounded by the manner in which disclosure has been made to them, with lengthy delays followed by extreme pressure to produce evidence in short timeframes. They have also been distressed by what has seemed to be disregard for their privacy concerns and disparities in the approach taken to police witnesses. Strict rules prohibiting communications with each other have meant that they have been unable at times to rely on each other for support. They do not consider that a trauma-informed approach, which recognises their special need as victims for fairness and due process, has been taken to their engagement with this inquiry. They have suffered as a result. They are disappointed that no panel member with relevant experience will be appointed to consider recommendations. They continue to hope that improvements can be made to the inquiry process which properly recognise their status as victims and accord them the special care and respect which they deserve.
Thank you very much indeed. I'm now going to move to the last of today's submissions, Mr. Scobie, King's Counsel.
Thank you, sir. I appear along with Piers Marquis. We are instructed by Paul Herron of the Public Interest Law Centre. We represent the Campaign for Nuclear Disarmament and former leading member of the Socialist Workers' Party, Lindsey. We also represent Michael Chant of the Revolutionary Communist Party of Britain, Marxist-Leninist. These are short submissions on the evidence of the managers and security services. We have provided written submissions available on the PILC website. They are summarised here. So, at the end of Tranche 1, you found that the infiltrations of both the SWP and RCPB-ML were not justified. In Tranche 2, the SDS themselves conceded the lack of justification for deployments into the RCPB-ML by ending the infiltration. In respect to the SWP, the Met Police have focused on the events at Welling in 1993. We have extensive submissions on the evidence around Welling, which we will return to in Tranche 3. We ask to be allowed to develop wider submissions on both organisations at the close of Tranche 2. Our focus now is on CND, partly because the deployments into the peace movement started and ended in the Tranche 2 period, and partly because both the Met Police and the security services have sought to argue justifications for the infiltration of CND. Those justifications are not supported by the evidence. There is silence as to A, who authorised the infiltrations, and B, what the highly personal and intrusive reporting was used for. Security services. Witness Y weakly asserted that A, CND was assessed to have been infiltrated at a national level by communists, and B, it took until 1985 for MI5 to work out this was no longer true. That is contrary to the evidence. Even in the 1970s, when Communist Party members had occupied 8 of the 15 seats on CND's National Council, MI5 had not required STS intelligence on CND. Those days were long over when John Kerry was deployed. In February 1982, the STS assessment was that Communist Party influence had waned quite dramatically, and there was no foreseeable likelihood of Trotskyist influence growing, in particular on the National Council. MI5 reviewed and agreed with that assessment. Witness Y conceded, in line with Cathy Massiter's account, that MI5 did not consider CND to be a subversive organisation. They did not explain why they continued to encourage reporting on individuals they knew were not subversive. MI5 was silent on the ethical implications of encouraging long-term undercover deployments against political activists and campaigners. Witness Y recognises the weakness of MI5's justification, yet, rather than concede it, the security services adopt a revisionist approach, implying that spying on the peace movement was more acceptable then than it would be now. Lord Denning said in 1963, "For most people it would have been intolerable to us to have anything in the nature of Gestapo or secret police to snoop into all that we do. It would have been considered an unacceptable intrusion, a waste of resources and an egregious example of state interference in the democratic process." MI5 cannot pretend that things were different then. They were not. The proof is in the wide public denunciation of the investigation to Madeleine Haig and the widespread public anger to the Cathy Massiter revelations. It is in the instigation of the Home Affairs Select Committee inquiry into the activity of Special Branch in 1984. The most damning proof is the Security Service's own collusion in deceiving the public by stating they and the Special Branch did not cover law-abiding non-violent activities like CND activities. They plainly did. STS managers. The senior police officers in charge of the STS between 1981 and 86 have not assisted the inquiry. Most of the officers who managed CND deployments have passed away. The documents associated with their periods as managers disclosed by the Met Police and security services are silent as to both justification and authorisation. Detective Inspector Trevor Butler actively denied dealing with any officer reporting on CND, despite the clear evidence that he signed off many of John Kerry's early reports. Eric Docker, the SDS Detective Inspector for the end of Tim Spence's deployment, does not know what the justification was. All he can offer is that CND deployments, quote, would have given us intelligence on likely numbers and aims of particular demonstrations. Even the Commissioner's annual report from 1983 emphasises the peaceful and orderly nature of CND demonstrations. So, that explanation does not assist at all. Chief Inspector Malcolm MacLeod was sceptical about the civil disobedience rationale that he himself noted in the 1986 annual SDS report. His firm position now is that the infiltration was not justified. In the documents from his time as a manager, he referred to CND targeting decisions coming from his masters. Those masters were clearly not MI5, because that is who he was speaking to when he used the term. A safe assumption is that his masters were chief superintendents and above within the Met Police. The only chief superintendent this inquiry has heard from is Jeff Craft, who claims to remember nothing at all. MacLeod claims that he cannot now remember who he was referring to. In respect of CND, whoever was pulling the strings was bypassing MI5. Tony Waite is a key manager. For the first 8 months of his posting as SDS Chief Inspector, he managed John Kerry, Lee Bonser and Timothy Spence. The documents from his time give some indication of the authority for the targeting. In July 1984, when Waite was new to the role, MI5 visited the SDS offices. Unusually, the S Squad Chief Superintendent, Ray Tucker, was also there. He'd recently taken over the command of S Squad from Jeff Craft. In the meeting, Waite said that in his view, 3 CND sources was too much. At the time, John Kerry was attending CND London Council meetings and had accessed the London Regional Office. The Security Service were concerned that his forthcoming withdrawal would leave a considerable gap, and it would take some time before Spence could fill it. Both MI5 and Tucker questioned whether it was necessary to end John Kerry's deployment. The upper echelons of Special Branch wanted to keep CND infiltrated. By November 8, 1984, when it was clear that Kerry's deployment was over, MI5 requested that Spence be directed against the SWP rather than CND. There was a strong precedent for doing exactly that. A, Chief Inspector Waite admits that most SDS deployments were in agreement with MI5. B, Waite admits that it was always our aim to deploy additional officers into the SWP. C, the SDS have not met MI5's request to have an officer infiltrate SWP HQ since the departure of Phil Cooper. D, at that time, the SDS only had one officer infiltrating the SWP, and E, that officer, Alan Bond, was not moving to the Brixton branch as he'd been told to do. Despite all of this, Waite refused the MI5 request and was set on making Timothy Spence John Kerry's successor in CND. Once again, the masters, whoever they were bypassing MI5 on CND targeting. 2 months later, in January 1985, the SDS were wavering on whether to continue CND deployments in the light of the Parliamentary Select Committee. Unsurprisingly, with the committee's focus on CND and the danger of Special Branch acquiring a sinister reputation for persecuting harmless citizens for political reasons, nevertheless, the deployments continued. Waite claimed not to be able to recall why he refused MI5's wish to task Spence into the SWP and instead continued the targeting of CND. He claims not to recall anything about the Select Committee proceedings or having any discussion with senior Special Branch management about the justification for infiltrating CND. He makes no mention at all of Cathy Masseter. He was in role at the time of her revelations, and he was aware that, as a matter of general practice, security service desk officers knew who SDS officers were if it affected their desk. In the 1985 annual report, he acknowledged that the Masseter disclosures were a breach of SDS security. He recognised that a failure in security would give rise to a possibility of embarrassment, not just for the Commissioner, which is the standard manager line, but for the government of the time. Waite's failure to even mention Cathy Masseter in his statement is astonishing. along with Chief Superintendent Craft and every other senior special branch officer with knowledge of the CND infiltrations, Tony Waite will remember Madeleine Hay and the Select Commission inquiry very well indeed. Special branch's panic around the Cassidy Mathester revelations would be unforgettable. Waite's retrospective justification for the CND infiltrations is weak. He cannot give a single example of contribution to policing public order. His second justification was that, quote, CND was targeted because they had the potential for subversion. Alongside his own definition of subversion, that amounts to the potential for a desire to change the natural order of things. That encapsulates Special Branch's approach, that they could spy on whoever they wished to, as long as they didn't get caught. On the issues of justification and authorization, the SDS managers have provided no assistance to this inquiry at all. Equally, the disclosure provided by the Metropolitan Police has provided similarly no assistance. The Metropolitan Police Commissioner. The Metropolitan Police submit that the deployment of undercover officers into CND and Lambeth Women for Peace was justifiable on two grounds. One, concern that CND could be infiltrated by communist groups in the KGB. Two, a US Air Force commander's written view that increased aggressiveness and venturism around the US air bases could lead to protesters being shot. The first submission is unsustainable. It doesn't explain the sudden interest in CND at exactly the time that Communist Party influence was widely reported to have declined. The reference to the KGB shows a remarkable lack of political understanding. The inquiry has itself acknowledged that engagement or affiliation with the Soviet Union would have been anathema to the groups infiltrated by the SDS. As far as their second submission, exhibiting correspondence between the US Air Force and the Ministry of Defense does not provide an evidential basis for a retrospective submission on a justification. It appears in an evidential void, not least because no police witness has ever mentioned it. In the letter to the Home Office attached to the 1984 annual report, Assistant Commissioner John Dello refers to briefings to provincial chief constables and Ministry of Defence police tasked with securing military installations in their area. There is no reference to any SDS report in either the sections on Green and Common or CND or the reports of Kerry and Bonser. There is nothing to suggest on the SDS's own material that the intelligence originated from SDS officers rather than another source. The inquiry cannot assess the value of any such briefings or whether any of the intelligence was sourced from Kerry or Bonser without having cited them. If the Commissioner wishes to provide an evidential basis for their submissions, the Met Police should look to their own documents and then disclose them. The US Air Force's proposed solution to protester incursions was an increase in RAF security and guard dog patrols at the bases. At no stage did the US Air Force suggest sending undercover police officers into the homes of law-abiding citizens. The Commissioner submits that the MPSB was obliged to monitor CND, linking that obligation to significant government and military interests in the 1980s. That is the firmest indicator yet of where the authorization for the CND deployments came from. Government targeting. The focus of the inquiry's investigations on government to date has been the Home Office. There is disclosure that suggests a rift between the Met Police and the Home Office in early 1983. The timing of that rift coincides with the recruitment of both Bonser and Spence. On 24th of January 1983, the MPSB finalised a report titled Political Extremism and the Campaign for Police Accountability in the NPS District. There is detailed analysis of the report in the Tranche 1 closing statement of Celius Stubbs. The report focused on the Labour-controlled GLC and local authority groups and their efforts to hold the police accountable for their actions. Outside of London, police forces were accountable under the Police Act 1964 to a committee drawn from the community that they policed. In the Met Police District, the statutory provision for accountability was different and no committee drawn from any community in the district had the right to receive a report from the Met Police or make a requirement of it. Historically, local councillors have voiced their concerns and objections to this state of affairs. The GLC had gone further and established a police committee and launched a campaign for accountability in the Met Police. The report suggested that this was an undisguised attempt to secure ultimate control of the Metropolitan Police. Special Branch followed the campaign in detail from the outset and collected a massive information about the personalities and groups involved. At least some of the intelligence came from the SDS. The report listed civil rights groups, members of parliament, councillors, law centres and bank account details. Many of those named have gone on to have successful political and legal careers. The police accountability group shared similarities with CND. They were single-issue campaigns with broad church support and policies backed by the Labour Party of the time. They posed no legitimate public order or subversion concerns. The report was politically partisan, an attempt to undermine the efforts of a democratically elected council to hold the police to account. Copies went to the most senior police officers and the security service. On the 27th of January 1983, a copy was sent to the Home Office. Commander Wilson described it as a most comprehensive report. Deputy Assistant Commissioner Hewitt called it important and sent copies to other senior officers so they could use it when dealing with and countering police accountability groups. The Assistant Commissioner, on behalf of the Commissioner, referred to it as an excellent piece of work. The response from the Home Office was not so complimentary. Sir Hayden Phillips and Sir Brian Coven discussed the report and contacted Hewitt to convey their, quote, very serious concern at the breadth and tone of a market for that report. Hewitt expressed his thanks that the matter was not being raised formally and undertook to reflect on what the Home Office had said. He replied on the 4th of March 1983, and I quote, "We are dealing here with a broader concept of public order intelligence, and on this particular aspect, I have probably gone as far as this special branch should go." There was nothing in the report that could be said to relate to public order. The response gives insight into just how far the Met Police felt they could push the ultimate defence line of jamming any activity into a public order justification. The Home Office saw that the response did not stand up to examination and believed the police did too. Hayden Phillips described Hewitt's reference to a broader concept of public order intelligence as meaningless as expressed and dangerous in application. Hayden Phillips told the inquiry MPSB had gone too far and were looking into legitimate political activity which was not subversive. It was in breach of the 1970 Special Branch terms of reference. Later in March 1983, the commander of Special Branch wrote to the Chief Superintendent C Squad, Derek Neal, and tasked him to continue. The most senior Metropolitan Police and Special Branch officers had decided, first, they could use Special Branch resources, including the SDS, to resist lawful attempts by a democratically elected council to make the police accountable to the community they were supposed to be serving. As an afterthought, the implausible ultimate defence line of a public order justification was added. Secondly, they could do so despite having been told by the Home Office that they could not, and having said via Hewitt that they would not. This was a willful assault on democratic activity, acting beyond police powers with knowingly unsustainable justification, in direct contravention of an order from a government ministry. The Met Police were intent on maintaining their own power. They would not have acted in this manner unless they were confident of support and not from an authority higher than the Home Office. There is evidence that in February and March 1983, the Met Special Branch were engaging directly with the highest levels of government. Margaret Thatcher had made a direct and specific request to the police in respect of intelligence on the peace movement. That led to the requirement of Lee Bonser by Neil. Malcolm MacLeod indicated that as the SDS Chief Inspector, he would not be surprised if the Prime Minister had a role in Bonser's tasking because, and I quote, the whole thing became very politicised. Whilst Hewitt was writing his informal response to the Home Office concerns, Bonser was recruited, vetted and deployed. Spence was also recruited into CND and police accountability groups. Both Bonser and Spence have refused to come to this inquiry and elaborate on that evidence. National Archive releases from January to April 1983 demonstrate that the government was preoccupied with losing the battle of public opinion with CND over disarmament. The Prime Minister's office was concerned by the apparent success being enjoyed by CND and intent on devising ways of neutralising CND publicity. On the 31st of January 1983, the Prime Minister formed the Ministerial Group on Nuclear Policy and Public Opinion, and a special unit was to set up to devote full-time attention to media issues and think imaginatively about them. The group included the Secretary of Defence, Michael Heseltine, included Sir Robert Armstrong, who had signed the 1976 and 1977 authorisation for the SDS's continued existence. Armstrong has recently been accused of extraordinary perjury by the former Australian Prime Minister Malcolm Turnbull in respect of evidence he gave in 1986 when he denied the government's use of the author Chapman Pincher to manipulate a media narrative. In March 1983, the Ministry of Defence commenced the DS-19 propaganda unit, which launched a campaign against CND. The 28 CND members named in the Conservative press as communist sympathisers, MI5 had supplied DS-19 with information on only 7. John Kerry had reported on 27 of the 28, Heseltine's letter and speech on the 22nd of April 1983, referencing the narrative of the press campaign and the calculated political professionalism of full-time socialists and communists had been discussed in the Ministerial Group on Nuclear Policy and Public Opinion in the week before. In the same meeting, the group had discussed and welcomed an offer of help from Chapman Pincher. When MI5 let the government down by limiting their cooperation on party political issues, that laid the ground for the Met Police's bypassing of MI5. The earliest SDS report on CND in 1982 highlighted the organisation's spectacular growth in membership. It also made clear that the field of activity of CND's national and regional activities was, quote, aimed at swaying large bodies of influential opinion, including trade unions, the media, church groups and politicians. Swaying opinion is the function of any campaign. The state's concern was that CND campaigned against government policy and was very good at it. Both Kerry and Spence were targeted into the London CND Council, the most significant of those regional opinion-swaying executives. On any objective evaluation, their reporting was far more useful for countering campaigning than it was for securing military installations. The concern around public opinion was replicated in the 1984 SDS annual report. The purpose of those reports was to update the most senior Metropolitan Police officers and the Home Office on the groups infiltrated, the intelligence gathered, and the threats said to be posed. The focus of the section on CND was not on public disorder or subversion. It was on A, membership numbers, B, the political position, noting the Labour Party's official espousal of unilateral nuclear disarmament, and C, in Waite's words, that CND has skillfully manipulated public opinion over issues about which people are genuinely concerned. Waite says, I cannot now remember how I drew the distinction between CND campaigning to attract support for its cause and thereby bringing to public attention specific areas of concern, and a group skillfully manipulating public opinion. The word skillfully manipulated does not distinguish CND's campaigning from any other campaigning. The inclusion of these words emphasised that the Met Police and their masters considered that CND's campaigning had to be countered. The inclusion of those words in an annual report confirms that countering that campaigning was part of the SDS remit. Disclosure. The SDS managers, the security services and the Met Police have not assisted this inquiry with answers to the critical questions of A, why CND was infiltrated, B, who authorised, or C, tasked those infiltrations, and D, the use to which the reporting was put. In relation to Cathy Massiter, the security services disclosed one document and have insisted that further investigation would not be proportionate. woefully inadequate on an issue of such importance. In respect of the Met Police, Chief Inspector McLeod has referred to a high-level special branch directive that led to all files on CND being destroyed. While there may have been some justification on the basis of the Home Office guidelines for destroying files on the individuals, there can be no justification for the destruction of files on policy, liaison, authorization, and justification. Witness Z's evidence was that the pressure to investigate these organisations often came from the Prime Minister in Whitehall. We asked the inquiry to focus the Tranche 2 Module 2C inquiries and disclosure on not only the Home Office, but also on the engagement between the Met Police and the Ministry of Defence, the Cabinet Office and the Prime Minister's Office. Those inquiries should not be limited to the engagement in respect of CND, but should encompass the wider target base of the SDS. There's only one inference that can properly be drawn from the lack of engagement by the state. In the words of Chief Inspector Waite, the press would have made hay of the fact of us doing this, despite not being a police state. Conclusions. CND had affiliations from thousands of civil organisations. It organised in universities and through the churches. It had hundreds of thousands of members in local branches and nationally. CND was a mass democratic movement of ordinary people. But like governments before and since, the Thatcher government was terrified of two things. First, a mass movement of people, and secondly, democracy itself. So those are our submissions.
Thank you. We will now adjourn until tomorrow, when we will begin at 10 with Mr. Wood, Counsel, speaking on behalf of a dozen individual court participants.